All right, ladies and gentlemen, once again, good morning, wherever you are. Uh, Welcome to this simple discussion and a continuation of my discussion regarding introduction to criminology as an important subject matter, especially to first year students, again, for them to appreciate what is their course, criminology, and their future profession. So last time we were able to discuss what is crime, and remember that in criminology, that is one of the subject or interest of criminology, which is to study crime. And remember, when it comes to crime, it covers the criminal, it covers the law, specifically the criminal law, and it covers the criminal behavior. So these are part and parcel of what is a crime. And in the study in criminology, they can be studied or they can be separately subjected to study. No? So again, do not forget now, ladies and gentlemen, that there are four primary interests in criminology, specifically in the study of criminology or in the application of criminology, which includes crime, the criminal law, the victim, and of course the criminal behavior. No, so this is what we are discussing. So last time we were able to discuss the criminological classification of crime. Now and now we will proceed and discuss perspective, no, or the all about of the criminal law. Because remember this, the maxim nullum crimen nulla pena sine lege, which means there is no crime if there is no law punishing it. And what is the law that they are pertaining to? That is the criminal law. No? Then in our country, we have the revised penal code, which is the primary source of criminal laws, and the special penal laws or special criminal laws. These are created by Congress that defines and punishes specific crimes, which are generally speaking not present, no, in the RPC. So kung ano yung wala sa RPC, meron yan sa mga special penal laws respectively. No? So after we discuss the perspective about criminal law, which is the reason of defining a crime, then we could proceed in understanding what is all about a criminal and of course criminal behavior. No, so these are the very important things that you will see and subjected it for a study as far as criminology is concerned. So please be guided accordingly and do not forget no the topics that we are discussing. All right. So I hope you utilize this without skipping so that you will be guided accordingly. No? So let us start. All right. So that is the perspective of criminology uh, regarding criminal law. So again, remember this, in the Philippines, when you hear the word criminal law, then you will remember that this is a kind of law that defines a crime. So kung walang criminal law regarding a specific act or action of a person, then there is no crime. And again, as I said a while ago, the primary or number one source of criminal law in the Philippines is no less the revised penal code. So sa assignment ninyo that I gave to you, you will visit the library so that you will see an actual appearance of the revised penal code, specifically on book 2, no, as your reference to the given assignment. So let us proceed because criminal law is very important, no, in criminology, because this is the basis, this is the legal basis to say that a certain act is a crime. No? But before we proceed further, let us see some of the brief history of criminal law, because criminal law is not only for the Philippines, no, but in other countries they have their own criminal law. It is for the reason that criminology is the scientific study of law violations. It is beneficial to have a basic understanding of the criminal law. Because remember this, no, in the second scope of criminology, according to Sutherland, the second is the breaking of law. So breaking of law means violating the law. And what is that law that is pertaining to it is the criminal law. Okay? So what is all about criminal law? This is, even in the earliest time of human existence, no? 3,500 years ago, no? There was the first, no, acknowledged, no, set of law dated 1792, no? That is the Code of Hammurabi or Hammurabi. Yung Code of Hammurabi, no? Pag narinig mo yan, lalabas sa utak mo yung principle ng batas nito, which is known as Lex Talionis. Itong batas nito is nakita na naukit ito, naiukit sa bato, no? So engraved in stone, yung Code of Hammurabi. So pag sinabing code, it is a compilation of law, no? Or it is a compilation of laws. Pag pinag-uusapan batas, no? So, itong Code of Hammurabi, if you will, to cut the story short, pag narinig nyo yan, merong principle dyan sa Code of Hammurabi na yan. Galing yan kay King Hammurabi. Yung principle ng batas na yan is an eye for an eye and a tooth for a tooth, no? An eye for an eye and a tooth for a tooth. In other words, kung ano ang ginawa mo, kabigat ang ginawa mo, ganun din kabigat ang penalty mo. Yan ang ibig sabihin yan. So, dyan na galing yung principle of lex talionis, no? Lex talionis, which means law of retaliation. So, kung ano ang ginawa mo, yun din ang gagawin sa'yo, no? So, this code was adopted by Babylonian and Hebrew laws that existed as early as 2000 BC. We have also another code aside from Code of Hammurabi, that is the Mosaic Code of Israel, no? Parang mas nauna yung Mosaic Code, but remember this, the first set of recognized law is the Code of Hammurabi, no? Ito kasing Mosaic Code is hindi masyadong accepted, or there is no clear evidence, no, to prove its existence, no, or impact. So, but anyway, this has been also been discovered that the Mosaic Code of the Israelites was developed, no, or this developed the laws of the Old Testament, no, which is included in the Ten Commandments, no, that we know that you should know the Ten Commandments, no. Ang naunang batas, kasi remember, wala naman tayong, just like in the Philippines, we have no revised penal code that time, only in 1932, January 1, 1932, no? So, yan yung Mosaic at saka Code of Hammurabi, they just only show that even in the earliest time, people were able to control actions of people for them to maintain peace and order by virtue of making law. No, this will control the action of people, and they are proven by these two codes, the Code of Hammurabi and the Mosaic Code. No. So going further, criminal law is defined, and you should always remember, an act, or this is a branch of law which defines crimes, traits of their nature, and provides for its punishment. Aside from which, criminal law also define crime, no? Kaya pag sinabing define crime, it is the criminal law that defines crime. So as written herein, crimes are defined by two components, the specific act and the intent, no? But remember this, in the elements of crime, as far as the law is concerned, even there is no intent, there are some cases that still it is punishable because you are negligent, you were imprudent, you were negligent. That's why kung hindi dahil sa kapabayaan mo, hindi sana nangyari ang isang hindi maganda. That is why still you are punishable in certain cases, even there is no intent or motive whatsoever. But in a general sense, when you are dealing with the criminal law that defines crime, there are two components: the act, the specific act, and the intent. So, what is the Latin term, which is a legal term? No, as far as a specific act is concerned, we call it the actus reus, and the criminal intent in Latin means mens rea. No, mens rea. So actus reus includes the act and the circumstances under which the act occurs. So itong dalawa magkasama yan, no? Parang kung ibhambing mo ito sa elements or anatomy of crime in criminology, there are three, no? We have the motive, the instrumentality, and the opportunity. Pag nagsama yung dalawang yan, there is a crime or there will be crime. So likewise, in the criminal law, there are two components. To say that there is a crime, there is the act, of course, pag may napatay, kung walang namatay, kaya nga the body of the crime or the corpus delicti in killing incidents, to say that there is murder or parricide or infanticide, there should be the body of the victim, no, as the evidence that there is a killed person. So yan, huwag niyong kalimutan yung actus reus and mens rea, no? Alright? So there are different levels of criminal intent, or what is again criminal intent? Mens rea. There are levels of criminal intent defined by the elements of purpose, knowledge, negligence, and recklessness. So, levels of criminal intent: a person purposely commits a criminal act when he or she desires to engage in criminal conduct to cause a particular criminal result. Pangalawa, to knowingly commit a criminal act, or a person must know, believe, or suspect that an action is criminal. So itong A and B, talagang ang tao is, no, talagang sinadya niya, no? Ito yung number A or letter A. Yung pangalawa, alam niya that if he will do this thing, no, there is a penalty or it will result to the commission of a crime at pwede siyang makulong. So yan yung pangalawa, no? So ito is alam niya, rational. Kaya meron yung sabi ni Lombros ay bekaria, na ang crime is the result of the rational of a person. Alam niya ang gagawin niya at alam niya ang resulta nito. So, yung number one naman is talagang sinadya niyang gawin, plinano niya. Pero itong pangatlo, kakaiba, and pang-apat, because, no, dahil sa negligence, lack of uh, foresight, no? Ang imprudence is lack of skill, no? Dahil hindi ka masyadong magaling magmaneho, nakabangga ka. That is imprudence. Dahil sa kapabayaan mo, lack of foresight, dahil nagsiya-cellphone ka habang nagmamaneho, may nabangga ka, that is negligence. So I hope you can distinguish negligence and imprudence. So negligence, lack of foresight; imprudence, lack of skill. Yan. So ito, recklessness. So itong dalawa, no? Incomplete man yung elemento ng crime, walang intent yan, walang mens rea, itong dalawa, but still it is punishable because you are the proximate cause. Yan yung L que es causa de la causa es causa del mal causado. He who is the cause of the cause is the cause of the evil cause. So still it is punishable under the criminal law. But at least, kung dahil sa negligence and recklessness compared sa dalawa na A and B, mas mataas ang penalty or seriousness ng offense or crime sa A and B compared sa C and D. So, it is balanced, no? But still, they are both wrong. So remember, this criminal law serves several functions in the society. So ano bang function ng criminal law? As I said a while ago, as mentioned a while ago, the law or specifically the criminal law is created to control actions of people. No? Isipin mo na lang kung walang criminal law. It will create anarchy. Kung gusto mo mga rape, nag-rape ka lang ta, no? So, first function of the criminal law is to discourage revenge. Yeah, because the government rather than the victim is responsible for. So, it discourages revenge. Kaya nga sabi nila, wag mong ilagay sa kamay mo ang batas. Kasi meron tayong batas, bahala na ang gobyerno at ang batas na uusig sa taong gumawa ng isang krimen. Yan. Yun nga sabi ko, pag walang batas, then pagpatayan yan, walang ending yan. It is no ending process. Patayin mo, patayin ka, patayin siya. So, you know, never ending. No? Gulo lang yan. Then second is the law serves to express public opinion and morality. Yeah, because if there is a law, then everyone have the right to due process. Hindi pwede mayaman o mahirap, you know, pag batas ang pinairal, walang mahirap, walang mayaman, no? Then pag may nangyari, pag ikaw ay nasentensyahan dahil dinaan sa batas at ginamit ang batas, then walang masasabi ang ibang tao pag ito ay dumaan sa batas. Then third, punishment method meted out according to criminal law serves as a warning to other citizens who may be thinking of committing. Itong number three is when we use the criminal law, because of the existence of criminal law, pag ikaw ang isang tao is na-convict o nasentensyahan dahil nag-violate ng criminal law at nakulong, then ito yung sinasabi ko noon sa inyo, it becomes a deterrent. It becomes a deterrent to other people. So what is deterrence again? Deterrence means giving of example for others not to do the same act or not to do an act that because, mapaparusahan ka. So yan. So do not forget the functions of the criminal law in the society. Ganon ka-importante ang criminal law. Alright? Then, of course, going further, specifically speaking, as far as the Philippines is concerned, there are elements of crime according to the criminal law. Yan yung sinasabi niyang trait of their nature. So, gamit yung criminal law, you will establish whether the elements of a specific crime is committed, no? So, the criminal law as a branch of law which defines crime, traits of their nature, and provides. Itong traits is, you have to define, see if the elements are present, no? Katulad ng murder. Oh, tingnan mo, may namatay, may pumatay. Yeah. Yung pagpatay ba is sinadya? Yeah. Plinano? Yeah. So pag meron yung mga yon, you can say now that there is murder. Yun yung how to treat the nature, no? Based on the elements of crime. So sino ang nagpo-provide sa definition, sa elements, and the punishment? It is the criminal law. And what is the criminal law of the Philippines? Primarily speaking, that is the revised. Bakit revised? Kasi meron tayong old penal law. That is why it is revised. Kailan na-revise? Again, it took effect on January 1, 1932. No? Ano ang batas na pinasa ng Kongreso para maging batas ang revised penal code? It is Act number 3815. Walang Republic yan. Act. Because that was in the early times in the Philippines. Okay? So do not forget. Our criminal law, no? And it is even recognized by international law. The characteristics of criminal law. Itong characteristics is important para alam mo, example, pag nasa criminal justice ka, and even as a criminology, itong characteristics will signal you or gives you an emphasis. No? Itong characteristics of criminal law, it only emphasizes how the criminal law is being used and applied, no? Paano ginagamit, paano ina-apply ang criminal law sa Pilipinas, no? So first characteristic of the criminal law is generality. Ibig sabihin, lahat ng tao, all people, whether foreigner or natural-born Filipino, habang sila ay nasa Pilipinas, then they are covered by the criminal law that if they violate, ah, okay, so itong generality, again and again, it will remind you that the criminal law will be applicable to all people, no? Living or sojourning. Pag sinabing sojourning, yung mga foreigner na they're here for temporary living, still they're covered if they violate the criminal law. So no one is above the law, no? But of course, ang generality may exception yan, no? May exception yan. So, yung mga exception, it is based because of public international law. Meron tayong international law, no? That is to prevent war. Example, yung President ng Amerika, kahit pumunta sa Philippines and they violate the criminal law, you cannot prosecute and punish the President of America or else it will cause war. So to prevent war, merong mga ganyang exception, no, based on international law. Yung mga ambassador ng mga different countries, if they are in the Philippines and they commit a violation of the criminal law, they are exempted from criminal liability. Yan. Okay? So, pag matututunan niyo yan, if you will go further in your subject criminal law. No? So, ito yung mga exceptions sa general application of the criminal law. Mga head of state like the president, the prime minister, ambassadors, ministers, and charge the affairs. No? So, this is adherence, as I said a while ago, to public international law. So even in China or in other countries, ganun din, they have to obey this international law. Second is territoriality. It means that the criminal law is only applicable within the territories of the Philippines, no? So lahat ng territories ng Pilipinas at nangyari yung isang krimen in violation of the criminal law, then you must be punished. So even, ikaw ay nasa registered Philippine ship, kahit nasa China ka, in a general sense, no? Kasi maraming explanation ito and you will learn them in your subject criminal law 1 and 2, especially law 1, no? Book 1. Ito basta ang isipin nyo dito is the criminal law as far as territoriality is concerned is only applicable within the territories of the Philippine island or Philippines, no? So kung ito ay outside the Philippine territory, then hindi na pwedeng i-apply. So kung ang krimen nangyari sa China, wala na tayong kahit Filipino pa ang nandun sa China at pumatay siya doon, wala na tayong kapangyarihan. The Philippine government or Philippine criminal law will not be applicable there. May mga exception din yan. So pag nangyari ito sa mga embassy ng Pilipinas sa other countries, the embassy is the extension of the Philippine territory. Even Philippine registered vessel or ship, no, nasa China. Pero ang nagpatayan is doon sa loob ng registered Philippine ship outside the Philippine territory. Still, the registered ship of the Philippines is an extension of our territory, no? So do not forget that. Then, prospectivity, no? Ang prospectivity, it means that ang batas or ang criminal law is only applicable to the present and to the future. Hindi pwedeng i-apply mo sa past, no? Okay? So, So, this prospectivity, no? Kaya nga sabi na dito, a penal law cannot make an act punishable in a manner which is, it was not punishable when committed, no? That is not committed, that is committed. So, yan yung sinasabi, no ex post facto law. Hindi mo pwedeng sabihin na punishable ang isang act na hindi naman ito punishable by law. So, likewise, yung sinasabi natin that ang prospectivity, ibig sabihin ang criminal law is ginawa para sa kasalukuyan at para sa future. So, hindi mo pwedeng i-apply yan sa nakaraan. No? So, example, kung walang batas noong January 1, 2022 that punishes a certain act, for example, punishing the use of marijuana, for example lang. So, wala pang batas nung ginawa mo yon, kumain ka ng marijuana. Pero February 1, 2022, naipasa ang isang batas na bawal ng kumain ng marijuana. So, hindi sila pwedeng pupunta at arestuhin ka kasi ginawa mo yung pagkain ng marijuana na wala pang batas punishing it. No? So, yun yung ibig sabihin ng prospectivity. No? So, a law or a criminal law is applied for the present and for the future, not in the past. But again, in every rule, there are exceptions. No? So, may exception din yan. No? Isa, no? Yan yung tinatawag na pwede mong i-apply. Ang exception is may mga exception kung saan you can apply the criminal law, no, retroactively, no, or in the past. Retroactive effect ang tawag doon. Retroactive effect is applied when the law is beneficial to the accused or person involved or affected. Katulad ni Robin Padilla, noong pinasa yung amendment doon sa batas regarding illegal possession of firearm, no? Nung pinasa yung bagong batas, pinababa niya yung penalty ng illegal possession. Dahil bumaba, yan, beneficial yan kay Robin Padilla, kaya nakapag-apply siya, no? Again, in the case of Robin Padilla, because of the exception in the prospectivity or of law or the criminal law, it has been applied to him because the law is beneficial. So yan yung isang exception. Pwede mong i-apply yung criminal law sa nakaraan kung ito ay beneficial or favorable to the person affected. No, kaya siya napaaga at siya ay nakapag-apply ng parole at saka siya ay nabigyan at lumabas, no? At hanggang sa natapos niya. So, second is kung yung batas mismo ang nagsasabi that it will be applied even in the past or there will be retroactive effect, then it will be implemented or there will be retroactive effect. No? So pag sinabing retroactive, ibig sabihin you apply it in the past. No? So those are the three characteristics of our criminal law: generality, territoriality, and prospectivity. Again, details and more deeper understanding will be given in your subject criminal law. But I guess as of the moment, you should, you should know this. No? Then, ito yung elements of crime. No? There must be an act or omission. What is act? Again, actus reus. The act or omission must be in violation of law, of course, no? Then the act is committed either by dolo or culpa. Yan, yung dolo is with intent or malice, culpa is, because of negligence or because of imprudence, no? So what are the elements of crime by dolo? We have freedom, intelligence, and intent. So yan, merong intent. Freedom, you have the ability to do, no? Hindi ka pinilit. So iba yung pinilit ka, no? Yan. Intelligence, hindi ka baliw. Alam mo ang right or wrong. Then you have the intent and motive to do it. Yan. Okay? Then yung crime by culpa naman is, there is still freedom. There is intelligence, hindi ka baliw. Kasi pag baliw ka, you're already exempted from criminal liability. So, ang wala lang dito is yung intent. But ang meron is negligence or imprudence. Lack of skill, again, is for negligence. Imprudence. Lack of foresight is negligence. Lack of skill is imprudence. So, do not forget that. No? So, still it is punishable. Pero mas mababa in a general sense ang penalty for culpa compared to dolo. No? Then, classifications of crimes according to criminal law. Ito yung sinasabi ko sa inyo. That yung criminological classification per se and the classification of crime according to law or legal classification, magkaiba yan. But still, they are talking about crime. No? So, classification of crimes according to the criminal law. This is a legal classification. So first is according to the stages of the commission of crime. So first is attempted, tatlo yan. Attempted, frustrated, and consummated. Still, all of these are punishable. No? So attempted kung uh, uh, nag-execute ka na ng, uh, some of the element of a crime. No? So example, sa killing or murder, no? Kaya merong attempted murder, merong frustrated murder, merong consummated murder. So pag consummated, napatay mo na yung tao. Patay na. Ginawa mo lahat. Yung frustrated, binaril mo na, tinaga mo, sinaksak mo, but because of some intervention or sinerte siya, o may tumulong, nabuhay siya. No? That is frustrated. Ginawa mo lahat ng elemento ng crime pero still nabuhay pa rin at hindi naging successful. Yung attempted naman, andun na sa stage wherein you started. Kaya sabi niya, the offender commences the commission. No? Example, nakita na ikaw ay pumasok doon sa bahay nila, babarilin mo sana pero may dumaang pusa, natakot ka, hindi mo tinuloy. That is attempted murder. No? Or hinabol mo, tumakbo, that is attempted. Okay? So, these are the stages in the commission of a crime. Attempted, frustrated, and consummated. Okay? Pero sa special laws, katulad ng rape, walang attempted rape. So, may mga exception yan, and these are the things that you will learn as you go on in your studies in criminology. So, in rape, walang attempted. No? Walang frustrated, I should say. No? Merong attempted, walang frustrated. So mostly sa mga special penal laws or criminal laws, mostly walang attempted, walang frustrated. They are almost, pag ginawa mo, consummated na yan. Katulad ng illegal possession of firearm. No? Wala namang attempted dyan or frustrated. Basta may hawak kang baril na walang lisensya, wala kang authority, that is already consummated. No? Except itong tatlong ito na stages, common yan sa crimes defined under the revised penal code. Ha? So, manners of committing crime, no, as a classification, material crime, the three stages are present, we can call it a material crime. Then, no frustrated states, these are formal crimes. Yan. So, yung mga walang frustrated states, katulad ng rape, those are formal crime. No, kasi ang rape, the mere touching the labia of the woman, that is already consummated. Yung attempted siguro, you go and pinasok mo yung kwarto niya, hinubaran mo siya, and you have the intention, makita sa actuations mo, yung ipapasok mo sana, but may pusa rin na dumaan, ano ba yung pusa na yan? Hindi mo tinuloy, tumakbo ka. That is attempted, but frustrated is impossible. And according here, no frustrated states is formal crime. Then crimes committed by mere attempts, yan, flight to enemy's country, abuse against chastity. Yan, so attempt. So may mga crimes na it is attempted. So ibig sabihin, pag attempted, yan, may mga attempted crimes na punishable, like attempted murder, attempted robbery, yan, may mga attempted yan. Pero pag walang frustrated, at ang meron lang is attempted and consummated, formal crime yan. Then pag present yung tatlo, pwedeng may attempted, may frustrated, may consummated, material crime ang tawag dyan. So another classification is according to the mode of execution. Paano ito ginawa? The mode. So of course, dalawa lang yan, intentional and culpable. So dolo and culpa, no? Dolo and culpa. Intentional is dolo, culpable is culpa. Lack of skill because of that, but still it is punishable. Ito naman, according to gravity, of course, the seriousness of the offense. So may impact yung seriousness as to the effect of the crime. No? Effect. Okay? So, first is grave. That is the highest gravity. Grave. Yan. Sa term pa lang, grave. No? Or grave. So, grave felonies, those felonies which in the law imposes a capital penalty. So from prison mayor, pataas sa death or reclusion perpetua, wala nang death penalty ngayon. So ang pinakamataas is life imprisonment, no? So yan is grave felony. Pag ang penalty is 1 month and 1 day to 6 years, less grave offense ang tawag dyan or felony. Again, pag sinabing felony, these are crimes punishable by the revised penal code. Pag sinabing offense, these are punishable by special penal laws. No? So light offense, these are crimes with a penalty of arresto menor from 1 day to 1 month imprisonment. Yeah. So do not forget. Likewise, do not forget the term malainse and malaprohibita. Pag malainse, they are evil from the beginning. They are wrong from the beginning. Even in the early time until today, that is wrong. No, even in the Bible. Uh, then mala prohibita is the act is wrong because it is prohibited. Okay, so that is all about the criminal law. No, so do not forget the perspective or issues about the criminal law. That is an important one that you should always remember, because without the criminal law, there will be no crime. All right, so do not forget that. So let us continue. No, so you are seeing here the term criminal. So of course, saan nila binasa yan? Because criminal ang tao because he violated a criminal law, no? Because of the term criminal law. So, but do not forget, no, that technically speaking and legally speaking, you can only call a person criminal if he is already convicted by final judgment by the court, no? Pag nasentensyahan na guilty ang isang tao, then you can call him as a criminal, no? Pero habang hindi pa siya nasentensyahan, technically speaking and legally speaking, no? Pag siya pala ay pinagsususpetsahan, person of interest, the kaso, then suspect, no? Pag siya ay na-identify at kinasuhan na at may ebidensya sa kanya, we can call him as accused. Yeah. Pag dumaan sa hearing at na-convict siya and convicted, then he may be called as now as a criminal, a violator of the criminal law. No? So do not forget that. So a person who committed a crime has been convicted with final judgment by a competent court. The person who violated the social norm or one who committed an antisocial act. But again, generally they are using the term criminal to refer to a person who violated a criminal law. But again, do not forget, if they will ask you the technical and legal definition of criminal, then you should say that a person who is already convicted by committing a crime by a competent court. Then, as far as criminals are concerned, because ito yung main player, no? Ang criminal is the star. He is the superstar in the criminal justice. Kasi, bakit superstar? Siya ang parating mayroong sikat siya, no? Kailangan siya ay ma-observe yung kanyang rights. Marami siyang napakaraming rights. Yeah, but of course, may rason kung bakit ang criminal is may maraming rights, because the victim is represented by the government and the government is very large. No? Kung walang rights ang criminal, din pag gumawa na lang yan, parilin mo na lang yan. But because of many rights under the law and the constitution, then the criminal or the person who committed the crime will undergo the due process. So in criminology, there are criminological classification of criminals. Kung meron tayong criminological classification of crime, meron din tayong criminological classification of criminal. So pag sinabing criminal, tao. Ano yung ginawa niya? Crime. Very basic yan that you should know. So based on etiology, no, origin. Pag sinabing origin, etiology, no, acute criminal is one who violates a criminal law because of the impulse or fit of passion. Yan, acute ang tawag dyan. Yung mga dahil sa revenge, dahil sa galit, yan, yan, acute criminal yan. Pag siya ay gumawa ng crime. Then chronic naman is one who commits crime in consonance with deliberate thinking. Talagang planado, no? Iba yung nabigla ka lang at ginawa mo dahil sa galit, compared sa chronic, talagang ito yung mga, isa pa is buhay na nila or hanap buhay ang pagpatay or talagang they plan the commission of the crime, no? Based on behavioral system, ordinary criminal, that is the lowest form of criminal and criminal career. So ito yung mga, you know, tawag doon, on the spot criminal, no? Uh, Napuwersa lang sila dahil sa sitwasyon nila. At ito yung mga, minsan lang sila gumawa. First time, ordinary criminal ang mga yan. Dahil wala lang makain, gusto lang kung bumili or kumain ng masarap na pagkain, kaya siya nagnakaw. So this, ordinary criminal, petty criminal. Pero yung mga criminal na merong grupo at grupo ng mga edukado, skilled, magaling gumawa ng bomba, magaling gumawa ng dangerous drugs, and they are group of 2 or more, they are associating with each other to make criminal operations. They are organized crime. Or sometimes ito yung syndicated criminal. Then professional criminal, this is one with degree. So yung mga professional criminal, pag nagsama-sama sila, that is organized crime. So pag sinabing professional criminal, yan, ito yung mga professional criminal, pwede mong hambing ito sa white collar crime. So yung mga gumagawa ng white collar crimes, these are professional criminal because they are using their skill, they are using their education, they are using their knowledge and wisdom, specifically their skill in committing the crime. Okay? Then based on legal classification under the law, recidivist, this is based on the revised penal code. Pag sinabing recidivist, ang ginagawa nila is recidivism, ang tao is recidivist, no? The offender at the time of trial for one crime shall have been previously convicted by final judgment of another. So, itong recidivism, no? Example, ang crime mo is killing, meron ka nang ginawang krimen na isa na killing, gumawa ka na naman ng isa, no? So, paulit-ulit mo na lang ginagawa. The same title of the revised penal. For example, crimes against person, that is in the same title. Gumawa ka ng homicide, mamaya murder, mamaya parricide. So that is recidivism. Paulit-ulit na lang yan. Repetition or reiteration, that is the offender previously punished for which the law attaches equal or greater penalty for 2 or more crimes to which it attaches lighter penalty. So ito namang repetition. So example yung mga magnanakaw, nung una worth 1,000 lang, mamaya worth 10,000, mamaya worth 50,000 hanggang million. So they are only committing the same but different levels of crime, no? Yeah. Then habitual delinquents, this is an offender within the period of 10 years from the date of his release or last conviction of crime, of physical injuries, robo, estafa, is found guilty of any said crimes a third time or oftener. So, within the period of 10 years, so after 10 years, gumawa ka ulit ng krimen, then you can be considered a habitual delinquent. Yung isang repetition, the same act, but you are improving and improving. So iso nga iso, magnanakaw ka pa rin, but you are increasing your actions, no, and level of seriousness. Yung recidivism naman, you are you are convicted or you committed one crime, example murder, yan. Yeah. Afterwards, kahit na-convict ka dyan, or after release, gumawa ka pa rin ng isa, pumatay ka ulit. Yan. So, recidivism ang tawag dyan. Okay? But anyway, you should remember that recidivist, reiteration, and habitual delinquent, they are of different descriptions of a person who committed a crime. Then meron din tayong tinatawag na quasi-recidivist. No? Any person who commit a felony after having been convicted by final judgment before beginning to serve a sentence or while serving sentence. Then we have also classification of criminals according to Lombroso. We have the born criminals. The atavism described, this is all about the physical feature of a person. Criminal by passion. Yan. Influenced by great emotion. Yung mga biglang na high blood or dahil sa emotion na hindi na iniiwasan gumawa ng krimen. Insane criminal, of course, those who are insane or baliw. Then criminaloids, those one who commit crime due to less self-control. Yan. Yung kleptomaniac, example, kahit mayaman yan, pero pag nakakita ng isang bagay na hindi sa kanya, nasasarapan siya pag kukunin niya. Kaya sometimes hindi niya pipigilan yung utak, no? Na nagnanakaw na siya. So yan ang kleptomaniac o yung mga pyromaniac, pag nakakakita ng apoy, masaya siya, na nasasatisfy siya even sexually. Kaya hindi napipigilan na mag-set ng apoy. Yung mga mahilig, nasasarapan na mag-set ng fire, mga criminaloids kayo, no? Pyromania ang tawag diyan, no? Then occasional criminal, we already mentioned that before, occasional, no? Yeah. So, gumagawa lang siya in some instances, no? Occasional criminal diyan. Oh, dahil may pangangailangan sa isang banda, yan, gumagawa lang siya ng krimen occasionally. Pseudo naman, those who kill himself. Pag sinabing pseudo, false criminal, no? Because false because, you know, ang ginawa mo is justified. That's why hindi ka ikukulong, no? Then types of criminals by Garofalo, we have murderers, violent criminals, deficient criminals, and lascivious. Yan. Pag sinabi mong lascivious, related sa chastity. Yung mga nananansing, yan, sexually, lascivious criminal ang mga manyak at tao, sex manyak. Yan. Deficient dahil walang makain, may gustong makuha, kaya nagnanakaw. Yan. Violent, yan, they commit serious life crime, murder, homicide, murderers, violent, yung mga gumagawa ng violent, magamit ng baril, magamit ng weapons, dahas, violent criminals. Of course, murderers is these are people who do killing with purpose or intention. Okay? So, do not forget also that in a crime there is a victim, no? The one who is, the aggrieved party or the private offended party, the one whose rights are violated is the victim. But again, in criminal justice, the one who will represent the victim is the government. Kaya meron tayong prosecution or prosecutor. Yeah? In criminology, meron tayong tinatawag na victimology. That is a division in criminology that studies the participation of the victim, why the crime is committed. No? Then we have restorative justice, that is the opposite of punitive justice. No? Yung punitive natin is yan yung criminal justice kung saan kasuhan, sentensyahan at ikulong. Yan ang punitive. Pero ang restorative justice, that is, ang purpose ng restorative is to repair relationship. No? Yan. Kaya meron tayong katarungang pambarangay. That is one example of restorative. No? Para hindi na pupunta sa korte, yan, daan na lang sa usapan para win-win solution. No? Kasi pag kinasuhan mong tao sa korte, win-loss lang yan. May mananalo, may matatalo. At pag may natalo, masakit. No? Then victimless crimes, again and again, there is no really victimless crime. But as a matter of description, naging victimless because there is no private offended party. No? Yeah, so do not forget that. Yeah? All right, so we will continue our discussion in criminal behavior soon, no, in my next discussion. So for the meantime, we end the discussion after discussing what is all about the criminal law, the criminal, and the victim. So do not forget that. All right, thank you, and I shall end my discussion here. All right, thank you. So I hope you use this simple and humble discussion. No? God bless us all and be safe always. Thank you.